SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. Welcome to this current affair class. This is class number 27. This is going to help you in your upcoming prelims examination. Let's begin this class and let's see what's the topic. So topic is revolving around Justice Verma, Justice Yashwant Verma. Burnt cash has been found from his house. There have been many things happening now. He has been transferred to Allahabad High Court. There is a petition which is filed by the Allahabad High Court now. A PIL has been filed in the Supreme Court against this transfer order. Government has approved this transfer order, and whatever is happening is causing the public trust. The trust of public in judiciary is reducing, is deteriorating because of the events which are happening. Okay, so let's see what the topic is in detail and how this public trust is reducing or decreasing or deteriorating in judiciary. So in-house procedure, we have already done a video on in-house procedure which was called in action after this particular case of corruption was found, and a formal committee has been formed by the Chief Justice of India which is going to submit the report, and then the Chief Justice of India, if the person is found accused of judicial misconduct, then the person would not be getting any judicial work to do and at the same time would be asked to resign. And if he does not resign, then the Chief Justice of India can write to the President of India for initiating the impeachment process for the removal of the judge. So this is the in-house procedure, and the in-house procedure is already there in process, in progress. So talking about the trust of people in judiciary, it's a major issue in India now. If you see, these are the cases which have been seen recently in the past decade or so, which has eroded the public trust and which has also deteriorated the image of judiciary. It has impacted greatly the image of judiciary. One was the Soumitra Sen case in 2011. You know, this in-house procedure, it's a informal procedure, we can say, and it is not recognized by the constitution like the impeachment procedure which is there under article 124 and under article 217. Okay, this is something which has grown over the years through the judicial pronouncements. It in a way saves the dignity of the judiciary, because impeachment is very rigorous, it is very public. On the other hand, in-house procedure, in order to have a judge accountable for the judicial misconduct, that is a sort of, not a public, not a rigorous kind of an inquiry or investigation which is very much necessary in any public institution. And this also happened in Justice Soumitra Sen's case, but he refused to submit his resignation, and for that reason an impeachment process was initiated against him. Rajya Sabha has already passed the motion, and it was only the Lok Sabha which had to pass the motion. After that, he would have been removed by the President of India. But after the passage of the motion by Rajya Sabha, Soumitra Sen has resigned. So actively, we see there are no judges in India who have been impeached till now. So what did he do? Misappropriation of rupees 33 lakh and resigned before the impeachment. Justice Nirmal Yadav, 15 lakh delivered to wrong judge, triggering a CBI probe. Justice Narain Shukla, accepted bribe for medical college favor. No punishment was given. All these deteriorate the trust of public on the institution of judiciary. Justice T.P. Rao, he was the judge of the CBI court. He was arrested for accepting 5 crore bribe for granting a bail. Affidavit by Shanti and Prashant Bhushan. So they have filed an affidavit claiming that out of 16, 8 former Chief Justices of India were corrupt. Now, these things are not proved, but those events were sort of proved. deteriorating the trust which the people have in the institution of judiciary. Now, judiciary is a very important organization. It's a very important institution. You know, it is the custodian of the constitution. It protects the people's fundamental right from the excessive power of the executive or the excessive power of the parliament. It is the keeper of the fundamental rights, protector of the fundamental rights of people. And when people see that the temple of justice is corroding because of the characters of the judges sitting inside it, that's very painful. That is when the people start to question the authority. That is when the people start to question the faith they have in the institution of judiciary. So, concerns associated with judiciary. If you see, there are other concerns also which public keeps in mind. Pendency of the cases, number of vacancies which are there. Now look at this, judicial backlogs. There are around 5 crore cases pending as of December 2023. Huge number of cases pending. Forget about people who are not involved in these cases, but think about people who are involved in these cases. They never know when the judgment is going to come. There are civil cases which are running in the court related with property. Few people are unable to have access to their property because it has been wrongly taken up by somebody, and there is a case which is running from I don't know how many years, 10 years, 12 years, 15 years. Criminal cases running that long, taxation cases running that long. There is no day-to-day procedure or proceedings which are taking place in the court. One date is given and then the other date is given after 3 months or maybe 6 months. So this is how the cases are prolonged, and there is a pendency of about 5 crore cases in India, which is a very, very big number. Only 25% are resolved in a year. So number of cases filed, only 25% of those filed cases are resolved in a year. 40% take over 3 years. So this is the status. Then appointments and accountability issues are there. There is collegium system, and now questions are raised on collegium system also, because it lacks the transparency. It is only the judiciary who is appointing the people who will sit in judiciary. National Judicial Appointment Commission was an alternative, but this was declared unconstitutional on the basis of this evolving principle of basic structure, that National Judicial Appointment Commission may have the tendency to infringe upon the independence of judiciary. In one or the other way, National Judicial Appointment Commission would have more weightage of judges inside it. It was a 6-member committee which was made for appointment of judges, which was made for the transfer of judges, but this was struck down by the judiciary. So collegium system lacks external oversight. FIRs need CJI's approval. We will see how sanction is needed by the President of India after the consultation with CJI. This is one of the immunity which is given to the judges if some criminal proceedings has to be initiated against them. Chronic vacancies are there. 20+% judicial positions are unfulfilled. So a kind of overburdening on the judges are also there. Adjournment, abuse and unequal law application. Frequent adjournments, this is one of the big problem. Delays in justice and promote corruption. So justice delayed is justice denied. This is the phrase we have heard over and over again, and it fits very perfectly on the current status of Indian judiciary. First in, first out principle is often violated in the country. So sometimes what happens, the person who is wealthy or the case which is a very high volume case, they get the priority, and people who are not wealthy, who are not well to do, if they approach the court, usually it is seen that their cases are not taken up on priority by the judiciary. Now this is the violation of the first in and first out principle. So judicial accountability and K. Veeraswamy case. So after the pendency and the vacancy things which we have seen, people are also concerned with the kind of immunity which has been provided to the judges. Now it is important to provide immunity to the judges because they are doing something which is very important. They are keeping the justice intact, and frivolous complaints can be filed against them just to disturb their work or disturb the delivery of justice, and that is the reason why an additional immunity is provided to them under Article 124, under Article 217, and also through the pronouncements of the judiciary in several judgments. But people are more concerned about the corruption cases which are coming out now, and those people who have been allegedly involved in those corruption activities, they are being protected by the immunities which are provided. For example, if you see K. Veeraswamy case, it was a 1991 case which have given additional protection to the judge. Firstly, judges were accepted as public servant under this case, under the Prevention of the Corruption Act, and if judges are public servants, then they need a little bit of protection. If you have to file an FIR against a judge, consultation from CGI is necessary, and then CGI is going to recommend to the President of India to sanction an FIR against him, against the corrupt judge. So this is the procedure. It's a very long procedure. If a wrong has been done by an executive, directly a FIR can be lodged against him. But such a thing is not possible against a judge. Consultation is required, sanctions are required to file an FIR against him. So usually people do not like it, especially when the corruption cases relates to judges who sit in higher positions, such as the judges of the high courts. So moving on to the next slide. So we have already seen that judges are public servant under section 2, and prosecution is permissible only after sanctions and only after consultations by CGI. So if you see this, the category of judges and the sanctions which are required and the authority from which these sanctions are required, if it's a sitting Supreme Court and a High Court judge, then a sanction is needed. Similarly, if it is a subordinate judiciary judge, then also sanction is needed to file an FIR against him. If the person is retired, if it's a retired judge, then you can file a FIR against him. But if he is a sitting judge in the Supreme Court of India, in the high courts of the states, or in the subordinate judiciary, then sanctions are required. And who are the authorities who is going to sanction the FIR against them? The Chief Justice of India here, then the concerned High Court. So this is the kind of immunity which is given, but it has been misused by the judges who are involved in corruption cases, eroding the public trust on judiciary. So consequences and public perceptions, erosion of public trust. So this particular survey, 2013 survey of Transparency International, it has done that 45% of the Indians believed that judiciary is corrupt. This is a very high number, 45%. Can you imagine? There are 150 crore people in this country, and 45% of them thinks, give or take 45%, that judiciary is corrupt. Perceived corruption score is 3.3 out of 5. This is very disturbing. There is also a violation of Article 14. If you see, equality before law is compromised when wealthy and powerful dictate the judicial outcomes. First in, first out principle is also violated. First in, first out principle, as we have seen in the previous slide, because the people who are wealthy, their cases are fast tracked. It is seen. If it relates to a celebrity, if it relates to a wealthy person, their cases would be fast tracked. Whereas the cases of other people, normal citizens of this country, they go on for decades. They do not have the financial muscle to get involved in a in a case, and that also, you know, in one or the other way infringes upon their fundamental right. Also they does not want to get involved in judiciary, and in many of the cases when they can really move to the court, they just doesn't want to go to the court because they know justice will be denied. Why? Because too much time will be taken, and they do not have the financial muscle to cope up with that amount of time. So that is the reason why in many cases when people want justice, they want to go to the court to seek justice, they usually do not. And it is also a tool for harassment of the people. File a wrong case against a person and the person gets involved in a lawsuit for years. You know, that's also a sort of instrument through which many people harass other people. So these issues needs to be solved in order to restore the public trust in judiciary. Lack of deterrence. Accused judges often escape via resignation, transfer or delays. This is what is happening. Now, cash has been found in Justice Verma's house. There is an in-house inquiry which is going on, but at the same time, he has also been transferred to the Allahabad High Court. Now, Allahabad High Court, although does not want him, but that is what people are seeing. Try to think from the perspective of people, that if a corrupt judge is not removed but is transferred to another court with full authority, then what kind of justice is that? That is where this point comes here, that accused judges often escape through the immunities which are provided to them. Okay. So what is the way forward here? Fill all judicial vacancies, reduce dependency and corruption. So if you have all the judges sitting in, all the vacancies are filled, then the oversight over judges would improve, and at the same time the justice delivery will also improve. Government can keep a better track, or judiciary itself can keep a better track at the cases which each judge is looking after. The kind of corruption which happens may reduce with this particular step. Strict enforcement of adjournment laws, that's also necessary. Transparent appointments and disclosure. So again, the question of National Judicial Appointment Commission and questions related to collegium system are in light. Again, publish reasons for elevation of a judge from a lower judiciary to High Court, or from High Court to Supreme Court, and strengthen scrutiny. At the same time, independent oversight mechanism has to be there. Establish an independent judicial complaints commission. Now, who is going to be the member of that commission? It is very important. Is it only going to be judiciary, or people from executive and parliament can also enter into it? Because the issue of judicial independence is always raised by the judiciary. Same happened in the case of National Judicial Appointment Commission. And technology driven reforms are very much necessary. AI based scheduling, digital case tracking and e-hearing, all these can help in reduction of corruption in the institution of judiciary and restoration of the public trust. It is very much necessary. Judiciary is very important for delivery of justice. It is the custodian of the constitution, it is the custodian of the fundamental rights, it is the protector of the fundamental rights of the citizen, and it delivers justice, which is very important in the society for the growth of human beings. So thank you very much for joining me in this video. We are going to come up with the next important topic in the next lecture, which will help you in your examination. Till that time, bye bye. Thank you, take care and Jai Hind.